Um, again, if you guys are just joining and you're not on mute, if you would go ahead and put yourselves on mute, that would be great. I will leave time for questions at the end. Um, and we're going to talk about advanced directives and kind of all the different pieces from an overview standpoint. For those of you that don't know me, my name is Kaile Hilliard. I'm a licensed clinical social worker by background. I'm a former surveyor, and my company, Granite Peak Healthcare Solutions, provides social services consulting for a lot of the Cottonwood buildings here in Colorado. So it's myself, my counterparts, Jessica Casanova and Sarah Thomas, that are providing those services for you guys. So some of you have seen me, and definitely a lot of you guys have had interactions with the other two as well. So this is kind of tailored to Colorado. So I know if there's other buildings that are in other states that have joined, welcome, and we can talk about specifics for your state. But to get started, excuse me, I'm a regulatory nerd and I come from a regulatory background. So I was a surveyor back in the day. It's been a hot minute, but I have spent my entire career in consulting on being a regulatory expert and knowing the CMS regs inside and out and how they apply and how surveyors cite tags. So I want to talk first about the different tags that kind of are related to understanding advanced directives, and then we'll kind of talk through some of the specifics. So if you do have questions though, and you're like, oh, I don't want to forget that, just put it in the chat box and I'll look at it before we get off. So, okay. So the first tag to talk about is 578. This tag is request, refuse, discontinue treatment, formulate an advanced directive. Residents have the right to request, refuse, and discontinue treatment at any time. They are also empowered to formulate advanced directives, which are legal documents that outline their preferences for medical care in case they're unable to communicate those wishes later. This verbiage is directly from the tag itself, from the regulatory verbiage. So facilities have to take important steps, including, and this I bolded and underlined this piece because this is one of the ones where I feel like we miss the most opportunities is informing residents of their rights regarding treatment and advanced directives. So if you have somebody who's like, I don't want to nominate a POA, I'm not interested, you still have an obligation to provide education and training to that person about advanced directives, why it's important, give them the opportunity to review that documentation. And then you need to make sure that you put it also in your progress notes and that you put it in the care plan as well. And then from there, I would make sure that we're doing ongoing check-ins with that person to see if, they've kind of adjusted, changed their mind, are interested in more information. Because you will come across some of those patients who are like, yeah, no, I'm good. I don't know why I need that. But the regulation says you have to provide information to them and education. We are also responsible for documenting any advanced directives in the resident's medical record to ensure that care aligns with their resident wishes and directives. And if you've had somebody that has kind of frequently changed, flip-flop back and forth, family has said, yeah, I think we're okay with maybe going on hospice and pursuing, one route and has suddenly decided they want to throw everything at the person. We have to make sure that we have documentation to reflect all those conversations and any changes that occur. To meet obligations, facilities should have clear policies and procedures in place. This includes discussing advanced directives with residents at the time of admission and as needed, respecting and implementing their treatment choices and reviewing and updating advanced directives regularly. So I'm a systems person, and I always encourage buildings to think from a systemic standpoint. So this system ideally would start even before our residents hit our building. So if we have a good admissions crew that's out in the hospitals, I would hopefully be I would be hopeful that they would be asking for advanced directive information prior to them even, getting to our building. So that would be the first line of the system. The second line of the system would be once they get into our building that we have a process in place, either nursing completes the most form, for example, or DNR form, that information is completed at the time of admission when we're doing our initial assessment. The third step in that would be once social services, who is generally in charge of the care conference process, once that initial care conference is set up, that social services then reviews whatever information has been signed and completed. So whether we got it on before they even came to the door on admission or at admission with the initial nursing assessment. Then it would be at the first initial care camp conference, which hopefully we're doing, shortly after admission, that we review that information. From there, then it would be reviewed every quarter.
Hey, can you give me access to the UHC provider portal? I just registered Bellaterra's TIN number and it asked me for an approver, and I typed in your name and you popped up. And so it said it sent you an email.
Hey, Jake
It said,
Larson.
we have notified Camerly Wheeler to confirm your access.
Jake, can you put yourself on mute?
Okay, awesome. Thank you. Okay, bye.
Jake, Jake Larson, can you put yourself on mute? Is everybody on mute? We good? Okay, I'm gonna keep going. So the next part of the system that I was talking about was every time that we have a quarterly assessment, ideally social services would be reviewing what advanced directives information we have in place, making sure it's still consistent, and if there's ever a change in condition. So what do I mean by change in condition? They've had a sharp health decline would be one reason to kind of go through and reevaluate their decisions around advanced directives. If somebody had like a major choking incident and had to be hospitalized for any period of time, then I would also, have that conversation. But really, truly, any true change of condition would be a reason to review the advanced directives with a resident or responsible party member and make sure that that's still in alignment with what they want to do. Okay, the next tag to talk about is F678. This is cardiopulmonary resuscitation, CPR. So the requirements of this tag say that facilities must provide basic life support, including CPR to residents requiring emergency care prior to the arrival of emergency medical personnel, subject to the resident physician orders and their advanced directives. We also have to make sure staff are trained and certified in CPR, and CPR certified staff must be available at all times. So, what I see here oftentimes is we will get this tag when buildings don't match, the orders don't match what the advanced directives say. So our orders, the banners that go across our PCC like profile pages will say that they are a full code, but their most form says they're DNR or vice versa. And then we will see tags fall under this. I've also seen situations where somebody has explicitly said they do not want to be resuscitated, and nursing didn't know where to find the information, and CPR was started, causing harm. So this is also an important tag in the whole conversation about advanced directives because it's related to what we're talking about, right? Okay, so that kind of leads us into advanced healthcare directive. So an advanced healthcare directive is written or oral instructions that name someone to make healthcare decisions on your behalf. In Colorado, oral is accepted under certain circumstances, and I'll talk a little bit more about that later on in this presentation. The purpose of advanced healthcare directives, that means that it's going to communicate the person's wishes about medical care if they're unable to speak for themselves. And this line by itself, if you're ever uncomfortable having this conversation with residents, is one that you can use in order to provide education and training to them. So it's an essential tool that allows for decision making. It allows individuals to communicate their medical wishes and designate someone to make decisions on their behalf if they become incapacitated. Let me be clear, though, that because they're in a nursing home does not mean that they have to have an advanced directives at all. So if they enter into your nursing home and maybe they want to be a DNR, but they don't want to fill out a MOST form, we cannot require them to fill out a MOST form. If they want to be a full code, again, we cannot require them to do a living will as a condition of their admission into our facility. So they have the right to refuse filling out this information. Our liability then becomes providing education and training to the resident. So some of the common things that we do see in our worlds are living wills, and that includes medical wishes while they're still alive, as well as what they want to happen to their body after death. A medical POA or durable power of attorney for healthcare that selects somebody to make medical decisions on their behalf if they become incapacitated or too sick to make them themselves. If they don't have a living will, medical POA makes all those medical decisions, with what they are supposed to be taking what they think is the best interest and what that person would want into consideration. And then we have the POLST, which in Colorado, it's the most. So the POLST is the program that supports the most form in Colorado. But it's the POLST or the POST in other states, depending on which version they adopted. So in Colorado, we adopted the most form, which is medical orders for scope of treatment. And that makes decisions about whether or not we want that person wants CPR, whether they want they tube feeding, maybe being hospitalized or potentially using antibiotics. Those kind of things are covered under the post most. So we have to talk about a POA and a Colorado proxy when we're talking about this because like who's going to make these decisions and what form is there out there? So a medical power of attorney allows someone to make healthcare decisions on their behalf if they become incapacitated, while a general power of attorney grants broader authority to manage finances, legal matters, and other affairs. There are some power of attorney documents that do have medical health inclusions in them. So if when you're uploading information into PCC and you see that they have just a POA, you have an obligation to read through that POA and make sure there is a medical piece to it. If there is not a medical piece to it, then we provide education and training to the resident, the responsible party member, about a medical power of attorney, what powers it grants, and why it's important. So a medical power of attorney does not have financial pieces to it. It is strictly around medical and healthcare decision making. So again, if you have the general POA and that's all you have, and you think, and they say, oh yeah, this is our POA document, you need to make sure that you've actually read through it and that it has a medical piece to it. A Colorado proxy form, and this is specific to Colorado because not all states do a Colorado proxy. Some states require like emergency guardianship. We are fortunate that we do have this proxy form. And this is a proxy decision maker for medical treatment. It is a legal document that allows someone to make medical decisions on behalf of another person when they lack decisional capacity. It is used when the individual cannot express their own wishes or make their own medical decisions due to incapacity. So with that, a physician must determine that the patient lacks decisional capacity, and then a proxy decision maker is appointed. And there's on the Colorado form, there is a place for all interested party members in that patient's care should all agree on who that proxy should be. If they cannot agree, they don't agree, then your job is to encourage them to go the guardianship route and pursuing legal guardianship because that does happen. But ideally, like if we have a Colorado proxy and we can, get the decision making, at least we have that piece in place. If the person regains their ability to make their own decisions, then the proxy form is no longer valid. However, you still have to get a physician to then say that they now have the decisional capacity to make decisions for themselves. I have seen that happen as well. We have another document in the state of Colorado that we can use. Most people, everybody probably on this call is used to the most post, but there is another one in Colorado that is a DNR form. It's just specific to saying they don't want CPR. And here is kind of an example of the different forms in Colorado. So the 5 wishes, most of these you can find online, and now you have to kind of pay a certain amount for the 5 wishes unless you get so many copies. I think some hospices will keep copies and they might provide, some examples for you if you want to have it. And then our most form is this one. And then this is the CPR form. So it doesn't include the medical interventions piece or the artificial administered nutrition piece. It just talks about whether or not they want CPR and whether or not they're going to donate their tissues. So it's a simpler form, but it is an also acceptable form in the state of Colorado. So again, we can't, as a condition of admission, we can't make people fill that out the most form. We talked about that. Okay, the Advanced Healthcare Directive usually allows a designated person to make health decisions. The validity of prior documents. A prior durable power of attorney for healthcare remains valid unless changes are needed or a new one is completed. The agent for the patient should be someone that they know and respects their wishes, and the agent cannot be their primary healthcare provider or facility staff. When we have residents who maybe aren't able to sign, but they are cognitively intact, generally you have to have 2 witnesses of qualified adults, and they usually can't be a physician, agent, or facility staff. So if you do have somebody that's going down that route, you have to find a couple of other people to be the witnesses, or they do. Again, completing the advanced directives, you don't necessarily need an attorney to complete the advanced directives, although some people will use attorneys before they ever admit to us to complete their advanced healthcare directives. And they can also write out specifics on their advanced directives, like only try to utilize artificial nutrition for 30 days, or if in 2 weeks I am not making any progress, then remove it. So that people can detail out specifically what it is that they want. So good reasons to create the healthcare directive. It will ensure desired care and services are provided, prevents undesired care from being administered, hopefully, names a trusted individual to make decisions, should ideally avoid family provider disagreements in critical moments, and increases the likelihood that their medical wishes will be respected. So if we want to change or revoke a healthcare directive, and we talked a little bit about that, they can do that at any time. They have to clearly inform their agent and healthcare providers, preferably in writing. And then the new advanced healthcare director, it overrides the older one. Oral instructions are valid until revoked and can supersede written ones if they were done after the fact. But it has to be with oral. You should have witnesses that witness the oral directions. A written advanced healthcare directive is valid indefinitely unless it's revoked or expiration is specified. An oral is valid generally during a specific illness, treatment, or stay. A new oral designation cancels prior written instructions. So here's the information specific from Colorado around the statute that covers oral advance directives. So if a person provides instructions orally, it's crucial to do so in the presence of a witness. While we prefer written ones, Colorado law does allow for oral ones, especially when the patient cannot communicate otherwise. And then there is a psychiatric advance directive, which we don't see a ton of those in our nursing homes. I think in my career, I've only come across a couple, but this is valid in Colorado. A psychiatric advance directive is completed when the person with psychiatric issues are able to understand their preferences and communicate them. It gives them a little more autonomy and helps them be able to specify their wishes about how they want to be treated if they are unable to make their own decisions due to a mental health crisis. It also helps ensure that individuals have a voice in their care. They can include information about their desired treatment choices, such as medications, types of therapy, and preferred facilities that they're interested in going to if they have a crisis. And then they can also name a person or agency to make decisions on their behalf if they become incapacitated. It should be used, excuse me, by healthcare providers and others to guide treatment decisions if the individual is unable to make their own decisions. So here's what a psychiatric advance directive kind of looks like. It is a much longer document than our most form, but looks somewhat similar. So there's 6 pages to it, but this is the first page, and then they have other questions to fill out, and then who are the witnesses and their declaration. So if you ever do come across a psychiatric advance directives, you're going to be looking for all 6 pages. Best practices for advanced healthcare management, keep copies accessible. We should be sending out our advanced healthcare directives if a person is being sent to the hospital or to a different level of care. A copy should go with them. With the most form, copies are acceptable. Ideally, they're supposed to be on that Vulcan green paper. Um, we want to make sure that families, agents, healthcare providers are aware of the location and the contents of any advanced healthcare directive that's completed. Ideally, if they're out in the community, we would encourage them to keep a copy with them, and then ensure emergency personnel are aware of the advanced healthcare directive in urgent situations. So those are the resources I have for you. And then, so this is kind of the overview of the presentation I had. So I know it's quick and good. So now we can open it up to questions. So I'm going to look at the chat box too. Can you send us the pad form or do we download it from the internet? I can send it to you. It's on a link, but you can also download it from the internet. Any other questions? And you guys can unmute now. Anybody? Just so you know, I get a lot of questions about guardianship. What do you do if somebody doesn't have anybody designated and they need a guardian? There is a process that facilities can do, especially in the state of Colorado. So you can actually nominate and send in the information, not nominate, but you can send in the information for emergency guardianship to whatever county that you guys are in. It is a $200 filing fee. And then it becomes the court's responsibility to try to figure out who's going to be that person. And sometimes they'll involve APS. So it doesn't mean just because you fill out the paperwork that you're saying anybody in the facility is trying to be the guardian. You're saying you're a concerned person about their ability to make decisions or that they need a guardian, and then you're just filing that
Bill.
paperwork within the court system. Okay. Anybody else? All right. Well, quick, good. I hope everybody has a really wonderful Memorial Day weekend. I'll forward this out so you guys have it as reference. And of course, reach out with any questions at any time.
Thank you.
You're welcome.